Jurors are absent. I have a note here from Mr. Mock, who says, request to see reciprocating skill saw. I'm going to grant that request, but I'm going to bring them back in the courtroom and pass that saw to them. My concern is that the saw that was received in the evidence is illustrative. It's one that was described as identical to the one that Grant Hayes had purchased. During the course of the trial, no one asked anybody, any witness, to describe the noise that saw made. I expected one of you during your closing arguments to ask me to let you plug it in and turn it on. Nobody did. I don't want the jury to be doing any experimenting in the jury room with an item of evidence that was never used or depicted or described in any way in the courtroom. So I'm going to grant this request, but I'm just going to have the saw passed to the jurors in the form that it was offered. If they want to stand up and do anything with it, they can, but I don't think we're going to let them conduct any kind of experiment in the jury room with that item. I'm not wedded to that, but I'll hear you on it.
I would ask, I certainly understand that approach. I would ask what you intend to tell the jury about that.
Well, I'm going to tell them that there are rules of this court that set the protocol of the court when jurors are asked to examine certain items of evidence. And even if the parties agree that they can see it in the jury room, there are some items that the court cannot permit that to occur. And this is one of those items. Okay?
That's fine. I just wanted to understand what it was you
right.
wanted to tell.
That even though the parties had agreed that the jurors could see this item, and more importantly, that this is not, there's no evidence that this is the item that was actually used to dismember the body of the deceased. This is an item that is, there's evidence from which the jury could find that this is an item similar to or identical to it, but it's not the same item. Okay? Either side want to be heard on that?
There you go.
All right. Just I know how much the appellate courts discourage trial judges from allowing jurors to take an item into the jury room that somehow or another they can conduct some kind of an experiment with, and I don't want that to happen in this case. So. All right, let me see which exhibit number is that? Do we know? 11.
Your Honor, are you intending on the speech that you just gave us telling that to the jury as well?
No,
Okay.
no. I don't intend to say anything about it other than I'm comply with their request by 511, by having the sheriff pass this item down the jury for them to look at it, examine it, hold it.
I guess we'd ask that the box be included, because the box has the blades in it that go in the, so I guess if the box could be passed to them, they can help it.
Well, we'll pass the saw and then the box separately. Okay? All right, Sheriff, ask the jurors to join us, please. Indicated that you have a request to see the reciprocating skill saw, which I believe is, tell me again, Madam Clerk, 511? Is that right? I'm going to allow your request, but we're going to do this a little bit differently than the past request. Even if the parties agree to the fact that the jurors can see things in the jury room, there is a protocol. There are rules. I don't make them. The Supreme Court makes them about what jurors can actually examine in the jury room. And when those items involve some types of equipment, weapons, things like that, the court has instructed me that the jurors can examine those items in the courtroom, but they cannot take them back to the jury room. So what I'm going to do is I'm going to let, and I'll also remind you that the evidence says to show that this particular skill saw, as you will recall, no one contends is the saw that was used by Grant Hayes. All the testimony suggests that this is an item that is similar to or identical to that which he was seen purchasing in July the 14th of 2011. But this is obviously not the saw used in this case, so please keep that in mind as well. I'm going to allow this to be published to you by first having the sheriff pass it to you. Each one of you can hold it, stand up, do whatever you want to with it, but that's the manner in which you will examine.
Is it possible for someone in the court to actually turn it on? We want to hear how loud it is.
I'll consider that request in a few minutes. I'm going to let you look at it first. And I'm also going to pass the box, because the box includes the two saw blades right up here in the top of the box. So if you want to examine that to see what the saw blades look like, you certainly have an opportunity to do that. This item, Mr. Mark, your second question is a little bit more complicated. No witness in this courtroom has been asked to describe the sound of that saw. No witness in this courtroom has been asked to plug it up and cut it on. You've heard no evidence with regard to that fact. You're asking me now to you're requesting that I give you the opportunity to basically hear additional evidence that you have not heard. So I need to confer with the attorneys about that. I mean, this is an entirely different question that you've asked me. And so let me ask you to step back to the jury room and don't discuss that. Just don't stop deliberating for a moment till I resolve that issue. And I'll come back in just a minute. If you all step back to the jury room, don't discuss the matter further. I'll call you back in just a minute. All right, the jury was absent, and my suspicion was correct that the jury was more interested in knowing the sound of the saw than they were in looking at the saw. So I honestly don't believe I have the authority to allow them to have somebody plug this saw in and turn it on.
Well, and Your Honor, I just ask that whatever you're going to instruct the jury, we be that we know what the court intends to say, because I believe Your Honor just instructed the jury that there's no assertion that this was the saw that Grant used, and he didn't say that Amanda used. And so that...
I said that Grant purchased. Maybe. But if I did, I misspoke.
And so we just like to... The phrasing of how this is communicated to the jury is hugely important to us.
All right, fine. Thank you. Have we heard?
We agree with the court's position that...
I just don't think I've got the authority to answer to honor the request. I was obviously concerned as soon as I asked for it, and they were going to take it back, plug it in the wall, and see how much noise it made. Since either side could have done that during the course of this trial, had any witness do that during the course of this trial, had any witness describe that noise during the course of this trial, chose not to. There's no evidence before this jury as to what noise, if any, this item makes. So I don't think I have any authority to grant that request.
Is that Dr. Ross testified about, she's asked some questions, I believe, on cross-examination about the noise that would produce, and additionally, she testified about the different speeds that were put forward. So I would argue to the court that this isn't new evidence. This is just another way to look or perceive an object. It'd be akin to if there was a recording, the jury being able to see a transcript of the recording. Similarly with this object, it's a physical object. When it's plugged in, the amount of noise it made could be heard by the jury. I'd argue to you that this doesn't constitute new evidence, but rather it's just another way to look at evidence that's previously been introduced.
Well, it would have been a simple thing to have Dr. Ross cut the saw on and demonstrate the different sounds at different speeds. Nobody asked her to do that. I frankly think I have no authority to basically conduct an experiment in this courtroom with this item today that no one else has done and described previously. So since both sides elected not to provide that piece of information to the jury prior to the time the state and the defendant rested their evidence, the jury will have to make a decision without that information.
And Your Honor, I guess I would ask how that information is going to be expressed to the jury, because I believe you.
I'm going to tell the jury I am not permitted under the rules of this court to honor their request. Ask the jury to come back in, please. For the record, the jurors are again present. Ladies and gentlemen, it's been brought to my attention that I may have misspoken to you. It was not my intent to do that. If I use the term Grant Hayes used, please strike that from your mind. I intended to say Grant Hayes purchased the item which Grant Hayes purchased. The only evidence before you deals with what Grant Hayes purchased, and the court doesn't have no opinion as to what, if anything, Grant Hayes may or may not have done with what it was that he purchased. So please do not consider that in any way and strike that from your mind. I certainly meant to say the item which is similar to what Grant Hayes purchased. Also, I have determined on the rules of the court, and again, I don't make the rules, the Supreme Court does. I am not permitted to grant your request. You will have to decide this case based upon the information that you have before you at this time. Thank you very much. You retired to resume your deliberations. We'll wait to hear from you, and let me know when you want to go to lunch if you don't have a verdict, within a reasonable period of time. No? Okay. All right. Can we secure the jury room? We'll just secure the jury room so that nobody will have access to it, and we'll just leave all the items that you have in there. And but be mindful of the fact that you need to stop deliberating. So if a couple of you decide to spend some time in there at lunch, don't talk about the case. You can only talk about the case after all 12 of you are present and after we declare that you are to begin again and renew your deliberations. An hour? Is that enough? So we're talking about 1:30, come back at 1:30? All right, you'll be in recess until 1:30 for lunch. Come on back about 1:30. We'll bring you back in the courtroom, and I'll authorize you to proceed with your deliberations. Thank you very much. You're excused for lunch. All right, we're in recess until 1:30 for lunch. Thank you.